Okay, so this is an unplanned live, but we have a response from Vince McMahon to the lawsuit filed by Janelle Grant. And we also have a preliminary response from Janelle Grant that we're going to read first. So skip through that. That was 2 pages. She's requesting arguments in front of the judge to make the rest of her motion to strike the response that we're going to read in full from Vince McMahon. Now, the reason I'm doing this live is because I started to read it and there was so much buzz when the initial lawsuit against him was filed, but I haven't heard much buzz about this even though it was filed yesterday. And why not read it together? So first, let's pull up Janelle's response. It's short, we'll get it out of the way. So you can see here, it's only 2 pages. And then you can see she's requesting oral arguments. And it says Plaintiff Janelle Grant, they're just going to refer to her as Janelle from here forward, respectfully requests that the court exercise its inherent power to strike the inflammatory lies made in defendant Vincent K. McMahon from this point forward, his memorandum of law in support of his motion to compel arbitration filed yesterday. Instead of using his motion in the appropriate manner to raise legal arguments concerning whether this dispute must be submitted to arbitration, McMahon instead uses the preliminary statement as a platform to launch vicious falsehoods attacking Janelle's moral character in a transparent attempt to harass and intimidate her into submission. And we're going to look at this for ourselves, and you guys are going to be the judge. McMahon's easily refuted lies have no place in this case. It was not necessary, reasonable, or responsible to use a public figure filing to impugn Janelle's moral character. Indeed, McMahon's desperate attempt to distract from the legal substance of the motion highlights its weakness and the weakness of his overall case. This court has inherent power to strike a party's filings. Accordingly, Janelle respectfully requests that the court exercise that power to strike the motion's preliminary statement in its entirety and admonish McMahon and his counsel that such statements have no place in civil litigation. So, signed by her attorney here, Ann Callis, and we're going to switch over and get into Vince McMahon's response. And let me get the screen right for you guys. Should have everything on it. All right, so defendant Vincent McMahon's memorandum of law in support of his motion to compel arbitration. He said, let's arbitrate. He's got a whole index. This is going to be a long one. All right, so defendant Vincent K. McMahon respectfully submits this memorandum in law in support of his motion to compel arbitration of plaintiff Janelle Grant's complaint, which was filed back in January 25th, 2024, pursuant to the Federal Arbitration Act. Preliminary statement: by publicly filing her salacious, false, and defamatory complaint, plaintiff has brazenly and intentionally violated a binding contract to arbitrate. The complaint's outrageous claims of sexual abuse and coercion are pure fiction, plainly intended to garner publicity, and are flatly contradicted by plaintiff's own contemporaneous statements. So, this is how we're opening, guys. We're going to see what we get as we go along. Contrary to plaintiff's false allegations, plaintiff and defendant, collectively the parties, engage in a consensual relationship during which defendant never coerced plaintiff into doing anything and never mistreated her in any way. Now, this is no surprise. We expected that this would be the counter response, right? In fact, in a love letter plaintiff wrote to defendant shortly before the parties ended their relationship, plaintiff described defendant as my best friend, my love, my everything, praising him for being the wonderful, tender, vulnerable, hard on your sleeve soul you really are. It is incredulous that plaintiff, a then 42-year-old woman who claims on her resume to have a law degree from Pace University, would have written these words to the defendant months after all the events in the complaint of alleged abuse, coercion, and sex trafficking, in quotations, took place. At the time the parties met in 2019, plaintiff was not dealing with profound grief from her parents' death and struggling financially, as described in her complaint, and she had not been, quote, devoting years to around-the-clock caregiving of her parents. Those statements are complete falsehoods. That's an interesting claim. Based on a foreclosure action against plaintiff and her parents, plaintiff's father passed away on April 18th, 2017, 2 years before plaintiff met defendant, and his marital status was recorded as, quote, widowed, confirming plaintiff's mother had passed earlier. So they're saying too much time has passed for that grief to have been what she's characterizing it as in her complaint. Court records further show that contrary to her claim of around-the-clock caregiving, plaintiff's father lived in a senior care home in Stamford, Connecticut before he passed away, not with her, and the Grants' neighbors would bring plaintiff's mother dinner and help around the house before she passed. So, in other words, not around-the-clock caregiving. In fact, contrary to her story of around-the-clock devotion in the complaint, the foreclosure action on her parents' home reveals that the plaintiff was adamant that she did not want to be associated with any of this, and failed to respond to requests regarding the foreclosure action. And remember, like, stuff like that, guys, is public records. When you're talking about, like, property information, foreclosures, that probably wasn't that hard for them to go and grab some of this stuff. Affidavit of due diligence at 3. Indeed, plaintiff was so absent in her parents' lives that it took substantial time and significant effort for the creditor in the action to locate her and identify her as her parents' next of kin. So, someone was seeking, when you pass away, if there's debts to that estate, right? If someone in that estate that passes away, they owe money. When that death notice is filed, it becomes public record. If someone tries to open probate, you have to notify creditors. You have to make public notice so creditors have a chance to stake their claim and say, hey, this person owed us something. Now that they passed away, we need it to be paid up through this probate process, through however you got to go through to close the estate. So what they're saying here, a creditor was struggling to locate Janel Grant. So was she really giving 24 around the clock stuff? Care? That's interesting. So yeah, this is the fake sponsor of the show, guys. We're doing a promotion for Tracker on CBS. And you're looking for money that is owed? Tracker on CBS will find it. I should have told that creditor. They could have found Janel Grant sooner. In addition to falsehoods about her own background, plaintiff's complaint, and guys, the point of that is if you lie about these little details that are easily proven by public record, and this is what they're alleging, right? We're reading a filing. But they're saying, hey, look, we looked at the records. She lied about 2 things in her personal background. What else would she lie about? And then on top of it, in her initial complaint, she was using her status as a way to say, I was vulnerable during that period of time in my life. So there's 2 reasons to tackle that: a general credibility issue, and because it was used as leverage to create the storyline of how we got here, how Janel was coming to the point of filing that complaint initially. So in addition to falsehoods about her own background, plaintiff's complaint is further riddled with fabrications and omissions about her relationship with defendant. During the parties' consensual relationship, we should count how many times we see that consensual reiterated. Plaintiff and defendant knew that the other was also involved in other romantic relationships. Plaintiff was living in Park Tower, a luxury multi-million-dollar building in Stamford, Connecticut, with her longtime fiancé attorney, Brian Goncalves. Since August 2022, Goncalves has served as Senior Vice President and Chief Privacy Officer of Televisa Univision, and Goncalves, oh gosh, another name I can butcher. Goncalves, is it Goncalves? Previously held positions with MasterCard and Hewlett-Packard. Plaintiff and Goncalves, we need a nickname for him, just Mr. G, lived in the same luxury building as defendant, just 4 floors below, when the parties began their affair in 2019. Plaintiff would often visit the defendant, so that's Janel Grant, visiting Vince McMahon, at his condominium at all hours, including at 2:30 a.m., and we know what hours those are, guys. We're giving a specific example of 2:30, just so you know, to pursue their affair and then return back to her condominium with Goncalves the same night. It is nonsensical that the disturbed alleged acts in the complaint include violence, coerced sex, and forcing plaintiff to be defecated on were taking place before plaintiff returned to her lawyer fiancé 4 floors below without incident. Oh my God, the attorneys went there. So you're saying someone pooped on you, and then you return to your fiance, and it just water under the bridge. So in other words, is the fiance gonna have to come forward and be like, no, I'm a witness to that. I can attest that she came home that night. I can back up. There was an odor of mendacity. Like, they're really going there. Defendant was never contacted by Goncalves, who was on the board of the luxury building, anyone at that building, the police, any friends of plaintiff, or any lawyer or advocate for plaintiff at any time about the fictitious, extensive, years-long abusive behavior alleged by the complaint. Oh yeah, and that is the guys, isn't it like the 8-year anniversary of that? I saw TMZ said something about, speaking of Johnny Depp and Amber Heard, TMZ ran a headline today about it being the 8-year anniversary of Poop in the Bed Gate. So, yeah, that's interesting. And then, hey, Professor the film fan, let's see what you think about this, because it's very interesting already. So, leaving the company where they worked, after 3 years and having decided to return to their partners in January 2023, plaintiff and defendant agreed to end their consensual, so we're saying consensual again, affair, and separate from each other. With plaintiff leaving the company where they worked, World Wrestling Entertainment, the WWE, plaintiff and defendant entered into a binding contract, and we're going to get these details. This is actually what I saw, and I said, oh my God, why aren't people talking about this? So they go their separate ways, and she leaves WWE. They're going back to the people that they're both in relationships with. But they enter a binding contract to memorialize that agreement. And we have some info in this filing on the confidential settlement agreement. Covenant not to sue. Plaintiff initially wanted to include a term in the contract mandating, so this is Janel, wanting to include a term in the contract mandating that the defendant, Vince McMahon, could not move out of their shared building, but defendant refused to include that term and did not move out. Why? Plaintiff's contention that contract between defendant and WWE on the one hand and plaintiff on the other is not enforceable and is utterly meritless, but that is an issue for the arbitrator. In fact, because the parties wish to preserve the confidential and private nature of any disputes under the agreement, they specifically provided in the agreement that disputes would be resolved through arbitration. Plaintiff was represented by a lawyer who negotiated the agreement for her before she executed it. Now remember, they've already laid out the context here that she went to Pace University, and that the husband is also, like, well-versed enough. So, you have a third lawyer here, but you guys also know well enough. When defendant learned that plaintiff, despite her promises, had violated the agreement by wrongfully disclosing both the existence of the agreement and their relationship, he exercised his contractual right to withhold payment otherwise owed under the agreement. So, he was going to pay her as part of this agreement. And when you enter a contract like that, guys, there's got to be some exchange both ways for it to be like a binding, enforceable agreement. So when you write it, there's supposed to be things that both sides are supposed to agree to and take action on and fulfill. So we're going to get to those terms, but seems like he's saying he had a reason here. He didn't fulfill those monetary payments he may have agreed to because something else wasn't fulfilled first. We're going to get to what he's alleging because this is his filing. In response, plaintiff sought to harm him. She intentionally violated the enforceable contract with her salacious, false, and defamatory public filing. However, the FAA and binding United States Supreme Court precedent and plaintiff's own agreement require that if plaintiff wishes to proceed with her fictitious claims, she must do so in arbitration, not in this court, and that this action be stayed pending arbitration. And this is the type of motion that's being filed. All that case law we got to scroll through. But this is the memorandum of law in support of his motion to compel arbitration. So the whole purpose of this filing, even though it's a very lengthy response, and he's adding other context in there, is to tell the court, look, we both have an agreement, it's binding, we signed it, that we're supposed to arbitrate if anything happens. So why is she taking it here? And this is the pre-answer motion. Defendant does not specifically address the substantive merits of plaintiff's counts asserted against him. For the avoidance of doubt, however, defendant vehemently and categorically denies all allegations of wrongdoing in the complaint. So he's saying, just so you know, I'm denying everything that was in that complaint, but we're not trying to argue that in this motion because we're supposed to be arbitrating this before it gets to a court. Including plaintiff's outrageous claims that the defendant coerced plaintiff into unwanted sexual acts, sexually assaulted and or battered her, trafficked her, and defecated on her. And I think it's actually, I feel like people might shy away from wanting to repeat this word, but the more you keep repeating it, I think the point is to underscore that would be so ridiculous if he was doing that and she didn't tell anybody and nobody knew. And she would go right down the elevator, down the stairs, back to her fiance right after. Without incident. Those are false statements intended for publicity, and they definitely got it. But I don't know if it's false. And I think the general sentiment was kind of like people kind of believed it, right? I think more people seemed like they believed it than were questioning it. Just from everything I was exposed to. I think people were like, oh boy, that guy. Gross. So when the complaints allegations are adjudicated in the proper forum, arbitration, witnesses are called to testify under oath, and all communications between the parties, including those authored by plaintiff, which she intentionally did not share in her complaint, are produced. The allegations and claims will be disproven, and plaintiff will be exposed for the liar she is. Meanwhile, for the foregoing reasons and as set forth below, defendant's motion should be granted. So all of that, guys, and we're finally going to get into background. The plaintiff. What are you guys talking about over here? That's a good pun. You personally don't give a shit. Charmin Bear, new sponsor. And then, yeah, did Chillmonger cover the first filing? Honestly, it's a blur because so many people did. Like, you couldn't stay away from this filing if you opened up YouTube or X. Like, it was just viral. So plaintiff is 43 years old. She was born in 1980 to her parents, Jane Grant and Anthony Grant, and grew up in Mount Kisco, New York. Shout out to Mount Kisco. From approximately 1999 to 2002, plaintiff lived in Los Angeles, California, pursuing a career in acting. So she wanted to be an actress. 2001, plaintiff bid in an auction to be featured in the film Who Wants to Be a Movie Star as one of the actors with 5 lines and under. Subsequently, they're getting her whole IMDb. Subsequently, in 2006, plaintiff was featured in the film The Theory of Everything as a hospital receptionist. Plaintiff also spent the majority of her childhood and adult life as an equestrian rider and owning horses. According to another, she's probably okay with poop. According to another lawsuit filed by plaintiff against several defendants for alleged injury sustained by plaintiff's horse. Oh, the horse was injured. Poor horse. Plaintiff had moved back to the East Coast by 2012 and was actively involved in the equestrian community around the same time. When they met, plaintiff told defendant she had received a law degree but never took the bar exam. Based on her representation, defendant assisted plaintiff to set up meetings with WWE's Human Resources and apply for a position in the legal department as a legal administrator coordinator. Now we're going to get to the agreement, guys. So the parties' negotiation and entry into the agreement. The agreement's negotiation in monetary terms. The parties' consensual relationship, during which plaintiff was engaged with Goncalves and resided with him in a luxury apartment, lasted a little less than 3 years and ended in or about January 2022. And they're referencing the McMahon Declaration. On December 24th, 2021, shortly before the parties' relationship ended and was reported in the New York Post, Grant penned a lengthy email to McMahon in which she called him my best friend, my love, my everything. So, and that's cited down here in an April 1st letter, April 1st article of this year. They then negotiated an agreement under which plaintiff would receive monetary compensation in exchange for and in consideration of various mutual promises and covenants. So, the reason this footnote kind of matters, guys, is I'm sure they're going to submit this stuff. We've already heard that, oh, she withheld her own digital records or whatever, her communications. That would have made her look bad in her complaint. Of course, no one's shocked by that. That parenthetical was for us to pique our ears and be like, oh, what was left out? But common sense says that when someone's writing a filing, they write things that are favorable to their own side and ignore the rest. But here, New York Post had this love letter on April 1st, 2024. That's damage control. That screams damage control to me. Someone got, and I'm not saying it's not a real love letter. I'm just saying we're going to give it to the New York Post and we know they're going to talk about it, right? PR strategy. Plaintiff negotiated on her own behalf in the first instance. Did I miss something? They then negotiated an agreement under which plaintiff would receive monetary compensation in exchange for and in consideration of various mutual promises and covenants. So this is really the bulk of it. This is really what the judge is going to have to decide. This agreement here, was it binding? Is there supposed to be arbitration rather than a public court hearing? Plaintiff negotiated on her own behalf in the first instance. Defendant initially intended the monetary consideration to plaintiff under the agreement to be in the range of $1 million to $1.5 million. Plaintiff negotiated the monetary provision in the agreement by telling defendant that his initial offer of $1 million was not enough to compensate for the lost earning potential and the fact that she would be unable to continue the promised career trajectory of vice president. So she wanted to be vice president, as well as failing to last as a director for a full year. She negotiated the monetary consideration to the full amount of $3 million. As another example, plaintiff also demanded that the $3 million was to be paid as a lump sum, so she wanted it all at once as part of this agreement. A compromise was ultimately reached such that, as the agreement states, the first $1 million was to be paid upon the execution of the agreement, and the rest was to be paid in 4 installments. And we have a fee schedule, guys. We have a payment schedule. Monetary considerations to grant. Upon execution of this agreement by the parties, McMahon will pay the sum of $1 million to Grant within 10 days of execution of this agreement, provided all confidentiality obligations of Grant under this agreement are complied with in ensuing years. So, stipulation here. Provided all confidentiality obligations of Grant under this agreement are complied within ensuing years, McMahon will pay the following sums to Grant within 10 days of the dates listed below. February 1st, 2023. So she's going to get the first $1 million as a lump sum, $1 million as a lump sum within 10 days of the execution of the agreement. But then the following payments to get the rest. To get the rest of this $3 million. $500,000, as long as all confidentiality obligations were fulfilled, was supposed to be paid on February 1st, 2023. The next installment would be 2024. Just over 2 months ago, approaching 3 months ago. So let's find out what happened between these two payments. In the event of any disclosure by Grant of the matters required to be kept confidential under this agreement, McMahon shall have no obligation to make any payments set forth above, which would otherwise become due on the dates indicated, and all monies previously paid to Grant pursuant to this agreement shall be returned to McMahon in accordance with the terms of this agreement. So was there a payback clause? As plaintiff admits in her complaint, the parties each retained counsel. I thought she was going to admit that. I was jumping ahead. As plaintiff admits in her complaint, the parties each retained counsel who were involved in the drafting, editing, and negotiation of the agreement. Indeed, in the course of negotiating the agreement, plaintiff's counsel, Jonathan Shapiro, of Aiton Law Partners, in an effort to reinforce the strength of the arbitration clause, which is going to be discussed in detail below, proposed that the following language be inserted. So, her attorney suggests this language. In the event of a claim of breach under this agreement by any party that results in arbitration or any legal proceeding, the prevailing party, as determined by the tribunal or court, shall recover from the non-parties all of its resulting costs and attorney fees. Although the finalized agreement did not incorporate that proposed language verbatim, the arbitration provision states the prevailing party in the arbitration shall be entitled to recover from the non-prevailing party all of its attorney's fees and costs. The agreement's release of claims. In the agreement signed by all parties on January 28th, 2022. So the first payment, that's why they're sticking with that February date, guys, because that's, you round it. First one probably was paid like February 8th. But then they're sticking with February 1st because it's about a year after the agreement is signed. The parties mutually agreed to release any claims that they may have against one another. Specifically, plaintiff agreed, and they're saying specifically, plaintiff agreed, among other things, to release defendant of all claims she had ever, as a result of or in connection with her employment relationship with WWE, the termination of that employment relationship, and or any and all matters involved in her relationship with McMahon and other WWE personnel. The agreement states further, by signing this agreement, Grant acknowledges that she will have waived any right she may have had to pursue or bring a lawsuit or make any legal claims against McMahon or WWE and or any of its directors, officers, employees, agents, and representatives. Still further, the agreement states that Grant agrees that she will not cause and has not caused to be filed any legal action, administrative proceedings, arbitrations, or charges of any nature whatsoever relating to McMahon or WWE concerning matters within the scope of this agreement. And Grant covenants and agrees that she will forever forbear from pursuing any legal proceedings except if necessary to enforce this agreement, and that she will not in any other way make any additional demands to claims against McMahon or WWE. Finally, under the agreement, Grant agrees that she shall not institute or be a party to any lawsuits, either individually or as a class representative or members against McMahon and or WWE, as to any matters up to the date of execution of this agreement, and that Grant knowingly and intentionally waives any right to any additional recovery that may be sought on her behalf by any other person, entity, or local, state, or federal government or agency thereof. It's difficult to conceive of a more clear and unequivocal release and covenant not to sue. Defendant in WWE, especially if payments were already going. Defendant in WWE similarly agreed, quote, to release and forever discharge Grant from any and all disputes and cause of action, claims, demands, suits, damages, attorney's fees, expenses, debts, contracts, agreements, and any and all other claims of any other nature whatsoever against Grant, whether known or unknown, or whether asserted or unasserted from the beginning of time to the date of execution of this agreement, which McMahon and or WWE have or could claim against Grant. Now we're going to get to the arbitration provision, where if something happens, this is supposed to be arbitrated and not just out in the public. The agreement also contains a broad arbitration clause, which requires that the parties must first attempt to resolve, quote, any dispute arising under or out of this agreement, its construction, interpretation, application, performance, or breach contains an arbitration clause informally. If that attempt is unsuccessful, the arbitration clause mandates that the sole and exclusive legal method to resolve any and all disputes and or controversies is to commence binding arbitration under the Federal Arbitration Act. Now, this is where we're going to get into, there's legal events, there's case law, there's stuff that we're citing. So specifically, Section 10 of the agreement states, in the event of any dispute arising under or out of this agreement, its construction, interpretation, application, performance, or breach, the parties agree to first attempt to resolve such disputes informally and prior to taking any formal legal action to resolve such disputes. In the event any such dispute cannot be resolved informally, all parties hereto agree, and this is small, so let me bump this. Let me make this bigger. Go from here. So the parties agree to discuss the venue for any such arbitration proceeding if and when such dispute arises which cannot be informally resolved, but in the event the parties cannot agree on a venue, then the exclusive venue for any arbitration shall be in Stamford, Connecticut. The prevailing party, as determined by the arbitration tribunal, shall be entitled to recover from the non-prevailing party all of its attorney's fees and costs. And we can get that back to normal size. Oh, now I just messed up my windows. StreamYard's really nice because it's really easy to bring comments forward from the YouTube chat. Streamlabs is kind of picky, and OBS is just kind of annoying sometimes. But StreamYard really sucks about resizing windows. The agreement's confidentiality and severability provisions. Among other terms, the agreement also contains a provision pursuant to which plaintiff agreed to keep the agreement and information about defendant confidential. It also, I wonder if it explicitly outlines you can't talk about defecation. Although he's already called that unequivocally and vehemently false. It also contained a clear severability provision. In the event that any provision of this agreement is held to be void or unenforceable by an arbitration panel or court reviewing an arbitration decision, the remaining provisions shall nevertheless be binding provided. However, if any of the confidentiality obligations of this agreement are ever contended to be unenforceable by Grant, or are found to be unenforceable by any tribunal, Grant agrees that she shall return all monies paid pursuant to the agreement to McMahon. So she had attorneys help her prep this, and that's all in there. So in this lawsuit, there's a footnote here. In this lawsuit, Grant is erroneously contending that the confidentiality provision is unenforceable. Defendant therefore reserves his right to, at the appropriate time and in the appropriate forum, demand, among other things, that plaintiff return the monetary compensation of $1 million, which defendant has already paid plaintiff under the agreement. So do we not get a 2023 payment? Plaintiff's acknowledgement that she knowingly and voluntarily entered into the agreement. The agreement made clear that by signing her name, plaintiff represents that she is able to read the language and to understand the meaning and effect of this agreement, that she has read and understands this agreement and the effect of it, and that her attorney has explained it to her. And I guess she can't use the, have you ever been to law school? No, she can't use that excuse because she's been to law school and got her degree. She also unequivocally acknowledged that, quote, among the rights she is knowingly and voluntarily waiving by executing this agreement is the right to bring or pursue any claims or causes of action against McMahon and or WWE. Plaintiff commences this action in violation of the agreement. Defendant paid plaintiff the first payment specified in Section V.A. of the agreement in the amount of $1 million. However, because plaintiff failed to comply with her confidentiality obligations, which she breached by disclosing her relationship with defendant did not pay her the first of the four $500,000 installments specified in Section VB. So, this I need to see substantiated, because common sense would say, she filed this lawsuit this year. Not making that 2024 February payment kind of makes sense, but why did he stop it back in 2023? If that payment schedule said February 1st, 2023 was supposed to be the second payment, but the first $500,000 installment. Maybe they'll tell us. Then, rather than sue defendant for breach of contract and arbitration, in complete disregard of the clear terms of the agreement and her obligations thereunder, plaintiff initiated the instant action on January 25th, 2024, alleging various causes of action against defendant, WWE, and defendant John Laurinaitis. Don't give me a hard name. Laurinaitis, did I say that right? That's a weird last name. I don't like that. The allegations in the complaint are replete with falsehoods, misstatements, and irresponsible mischaracterizations of the parties' relationships. So, I'm ending this paragraph here, still confused. Do we have proof that she breached the contract before this February 1st, 2023 payment was not made? Let's see. Before we get into the argument, I want to say hey to Ghost43881. And I see that guy McFly is here, so hey to you guys. And then I don't know if we have any more Tracker at CBS promotions, but I'm just going to pull this one up because it seems good enough. And oh no, that guy screaming what a slobber knocker takes on a whole new meaning now. The Federal Arbitration Act provides that written agreements to arbitrate controversies arising out of an existing contract shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. The Act reflects a liberal federal policy favoring arbitration agreements. They've got all the case law. Oh. There is a strong federal policy favoring arbitration as an alternative means of dispute resolution. The question of whether the dispute is to be arbitrated, in other words, the question of arbitrability. I never had to say that word before. Arbitrability is an issue for judicial determinations unless the parties clearly and unmistakably provide otherwise. Oh, and this is coming from AT&T and comms workers. In determining whether to compel arbitration, a court must determine 1. Whether the parties entered into an agreement to arbitrate. 2. If so, the scope of that agreement. 3. If federal statutory claims are asserted, whether Congress intended those claims to be non-arbitratable. And 4. If some, but not all claims are subject to arbitration, whether to stay the balance of the proceedings pending arbitration. So, if some stuff is subject to arbitration, at the very least, you need to stay any other proceedings pending that arbitration first. The party moving to compel arbitration, quote, bears the initial burden of showing that an arbitration agreement exists by a preponderance of the evidence. So that's a low standard, right? The party resisting arbitration bears the burden of proving that the claims at issue are unsuitable for arbitration. We don't have a standard there, though. Is it the same? Any doubts concerning the scope of arbitrable issues should be resolved in favor of arbitration. In order to arbitrate, the particular grievances should not be denied unless it may be said with positive assurance that the arbitration clause is not susceptible of interpretation that covers the asserted dispute. Doubt should be resolved in favor of coverage. And then that's all the case law there. And then they note here that the Federal Arbitration Act requires enforcement of agreements to arbitrate and embodies a national policy favoring arbitration. In other words, all of this case law and the actual act itself, Federal Arbitration Act, should favor, you should lean to, yes, take this to arbitration and not to my court. Go to arbitration first. In deciding motions to compel, courts apply a standard similar to that applicable for a motion of summary judgment. That standard, quote, requires a court to consider all relevant admissible evidence submitted by the parties and contained in pleadings, affidavits, and draw all reasonable inferences in favor of the non-moving party. As detailed below, pursuant to the Federal Arbitration Act, plaintiff should be compelled to arbitrate her claims asserted in the complaint as required by Section 10 of the agreement. Now, we're going to go over Section 10. They're going to say Section 10 is valid and it's enforceable. So we have to prove this because we're arguing as long as it's valid and enforceable, you need to make her go arbitrate. The parties need to go arbitrate. Plaintiff knowingly and voluntarily signed the agreement containing the arbitration provision. The threshold question of whether the parties indeed agreed to arbitrate is determined by state contract law principles. Here, the agreement states that it was made in and shall be governed by and construed under the laws of the state of Connecticut, because this was in Stamford. Under Connecticut law, the arbitration provision contained in Section 10 is valid, enforceable, and irrevocable. Now, we had a footnote here. So, we're going to get into this argument here, but here's a footnote. She should be compelled to arbitrate, but if this motion is denied, and it should not be, defendant reserves his right to move to dismiss the complaint under Rule 12 of the Federal Rules of Civil Procedure based on plaintiff's release of the claims in Section 2 of the agreement. So, in other words, if I'm asking you to arbitrate, but this isn't an either-or request. I'm asking you to arbitrate because that's what, according to this case law I just presented, I'm making the argument that that's what's supposed to be done first. It was in this agreement. This agreement's valid and enforceable, and it's just case law and in the Federal Arbitration Act all favor arbitration. So that's where we should go with it. But in the event that we don't just decide that I'm, not able to move to dismiss the complaint, the initial complaint filed against me for the court pathway. As courts have recognized, the very point of an agreement to arbitrate is to reserve merits arguments for the arbitrator. So a defendant is not required to answer or file a Rule 12 motion while a motion to compel arbitration is pending. So, can't say I'm late, can't say I didn't respond, you can't just issue a summary judgment against me, because I have a right not to respond while I'm asking you to enforce arbitration. In Connecticut, the fact that a party signed a written agreement is usually conclusive evidence of contract formation. So, they both signed it. And then noting under Connecticut law that the presence of a written agreement is generally strong evidence of a contractual relationship. Indeed, this court recently noted that, under Connecticut law, when an agreement is reduced to writing and signed by all parties, the agreement itself is substantial evidence that a meeting of the minds has occurred. Now, we're getting into like estoppel territory. It has long been the law in Connecticut that, quote, where a person of mature years, who can read and write, signs or accepts a formal written contract affecting his pecuniary interests, it is his duty to read it, and notice of its contents will be imputed to him if he negligently fails to do so. So even if you don't read it, you don't pay attention to what you're signing, you're still responsible for it. And then they cite this case law here that says, holding the circumstances surrounding the making of a contract, purposes which the parties sought to accomplish, and their motives cannot prove an intent contrary to the plain, I think this was plain meaning of the language used in the contract. So we've got a typo here. Not only did the parties sign the agreement, they were represented by counsel when the agreement was formed. Plaintiff also unequivocally represented that she entered into the agreement knowingly and voluntarily. 2, she understood the agreement and its effect. And 3, her lawyer explained the terms of the agreement to her. Indeed, plaintiff negotiated the agreement to her advantage. Plaintiff is thus bound by the arbitration agreement, which is valid and enforceable. And then they're citing this case here, which found that the written agreement at issue was a valid and enforceable contract between the parties because, among other things, counsel for both parties were involved in the review and execution of the agreement. So we've already seen that presented up to this point where, not only, does Janel Grant have a legal background, she has a law degree, but her attorneys not only were present when it was signed, they also suggested language and helped, decide what was actually going to be the final verbiage. And then the next argument is plaintiff's challenge to the enforceability of the agreement as a whole, rather than the arbitration provision, should be denied by the arbitrator and not this court. Plaintiff's challenge to the enforceability of the agreement as a whole, rather than the arbitration provision in Section 10 itself, has no bearing on defendant's motion to compel, we have another typo, this action to arbitration, because the issue should be decided by an arbitrator. The United States Supreme Court addressed this very issue in Rent-A-Center West v. Jackson. There, the Supreme Court explained, there are 2 types of validity challenges under this section. One type challenges specifically the validity of the agreement to arbitrate, and the other challenges the contract as a whole, either on a ground that directly affects the entire agreement, such as the agreement was fraudulently induced, or on the ground that the illegality of one of the contract's provisions renders the whole contract invalid. So what was Janel's initial motion alleging, right? It was like sexual harassment and trafficking. So one of the provisions to keep that secret would make this thing invalid, right? So we're going to see an argument about that here. However, only the first type of challenge is relevant to a court's determination whether the arbitration agreement at issue is enforceable. This is because, as a matter of substantive federal arbitration law, an arbitration provision is severable from the remainder of the contract. And Section 2, I think this was to be FAA, states that a written provision to settle by arbitration a controversy is valid, irrevocable, and enforceable, without mention of the validity of the contract in which it is contained. To further clarify when a challenge qualifies as one that is directed specifically at the validity of the agreement to arbitrate, the court explained that in some cases, the claimed basis of invalidity for the contract as a whole will be much easier to establish than the same basis is applied only to the severable agreement to arbitrate. Thus, in any employment contract, many elements of alleged unconscionability applicable to the entire contract, such as outrageously low wages, for example, would not. That's probably why we're getting all these all these companies as case law. It was all, what was it, like AT&T, and we had a few other ones mentioned, would not affect the agreement to arbitrate alone. But even where that is not the case, as in Prima Paint itself, where the alleged fraud that induced the whole contract equally induced the agreement to arbitrate, which was part of that contract. So there was an alleged fraud, and then they make a contract that says, you can't talk about that fraud. We nonetheless require the basis of challenge to be directed specifically to the agreement to arbitrate before the court will intervene. In other words, if a party challenges specifically the enforceability of the particular arbitration agreement, the district court considers the challenge. But if a party challenges the enforceability of the agreement as a whole, the challenge is for the arbitrator. Following the Supreme Court's decision in Rent-A-Center, that was the other one, courts have routinely declined to consider challenges that were not directed specifically to the arbitration clause. Unless the challenge is to the arbitration clause itself, the issue of the contract's validity is considered by the arbitrator in the first instance. So, first time we're considering it, finding that the plaintiff's challenge based on unconscionability, I can't say that word, unconscionability, that's ugly, is a challenge to the contract generally, and the same exact losing argument made. So, this Rent-A-Center case sounded like a doozy. Here the complaint asserts that the Speak Out Act bars the non-disclosure clause and the disparagement clause in the agreement, and that, because these clauses are the core terms of the agreement, that the entire agreement itself is judicially unenforceable. Further, the complaint seeks a declaratory judgment that the agreement is void based on grounds attacking either the agreement as a whole or provisions other than the arbitration agreement. For example, the complaint asserts that, quote, the agreement, including the confidentiality provision, is impermissibly broad. That is, Ms. Grant entered into the contract under duress and undue influence. That, quote, the agreement is a contract of adhesion, that the agreement is substantively unconscionable, and that the agreement is void as against public policy. So, all of these are saying the agreement, the whole agreement, is a problem. None of these challenges make any specific reference to the arbitration clause, nor does the complaint otherwise allege any factual basis to challenge the arbitration clause itself, because there is none. Quite the contrary, drafts of the agreement indicated that the parties negotiated the arbitration clause at arm's length with help of counsel. Because plaintiffs challenged, let me pause here, because when we got in the beginning of this, he was like, oh, you're looking for work, we'll get you in, you have a law background, let's get you in our human resources department. So, now, it's like, oh, we hired you to kind of, because of your legal background to be in HR. But now we're pointing out all the ways you're sucking at the way you filed this litigation. So, it's also like indirectly saying she kind of sucked at the job she was sort of hired for. I don't even know what her actual title was. She went from like HR to director and was gunning for vice president of WWE. So, who knows? Who knows? Because plaintiffs' challenges to the agreement are exactly the type that either are directed to the agreement as a whole or are on the ground that the illegality of one of the contract's provisions renders the whole contract invalid, the issues of contract validity must be considered by who? The arbitrator. And we've got this whole footnote here. And this is all from this Rent-A-Center case still. Defendant will establish in arbitration that each argument plaintiff raises to invalidate the agreement fails under applicable law. As a brief example, contrary to plaintiff's assertion that she entered the contract under duress or coercion, courts in Connecticut have repeatedly held that if the party who executed the contract under duress accepts the benefits flowing from it or remains silent, as I'm saying, that payment is important. It goes to estoppel. So she said she was under duress. But there's this case law. Courts in Connecticut have repeatedly held that if the party who executed the contract under duress accepts the benefits flowing from it, or remains silent, or acquiesces in the contract for any considerable length of time after opportunity is afforded to annul or avoid it, that party, because of his or her ratification of the contract, cannot assert duress or undue influence as a matter of law. So they're setting a 1994 case here. And then it says collecting cases. So is that an indication they're looking for more case law? This paragraph, collecting cases? Indeed, courts in Connecticut have found that even 2 months were too long to raise duress and undue influence argument. So, there's also precedent about the length of time that constitutes any considerable length of time after the opportunity is afforded. 2 months. So, 2 months. And we have a year. Well, we have 10 days, right? Because he didn't make that first payment. The agreement was executed on January 28th, 2022, and the complaint was filed almost 2 years later on January 25th, 2024. So I get it. So they're saying she didn't try to have an opportunity to say, oh, we need to annul this until this year, even though she accepted that first $1 million payment. So in the interim, as the complaint admits, plaintiff received and accepted the initial payment of $1 million upon the execution of the agreement. Plaintiff's clear ratification of the agreement and her willing and voluntary acceptance of its benefits, which lasted years until recently, refuted her allegations of duress and undue influence as a matter of law. Now, just a reminder, guys, they did part of that agreement that we got to see the bits and pieces of was also to protect anything against her. So it's unclear that if that's, a benefit she's been benefiting from actively in this time period. They don't go into any of that here. Plaintiff's claims fall within the scope of the arbitration agreement. In accord with a strong policy favoring arbitration, federal courts read arbitration clauses as broadly as possible and, quote, any doubts concerning the scope of arbitratable cause issues should be resolved in favor of arbitration. So we're seeing a bunch of cases now, and again, this act, they're going to quote this act again. The most favorable light is given towards being in favor of going the arbitration route. Indeed, the Federal Arbitration Act leaves no place for the exercise of discretion. No place for the exercise of discretion by a district court, but instead mandates, must, shall, that district courts shall direct the parties to proceed to arbitration on issues as to which an arbitration agreement has been signed. So there's no discretion. Here, all claims alleged in the complaint are within the scope of the arbitration clause, which broadly provides that the parties must arbitrate any dispute arising under or out of this agreement, its construction, interpretation, application, performance, or breach. The sad part about arbitration, guys, and I don't know if, the civil side, how public that would be in Stamford, how accessible that district is. But arbitration, we wouldn't get to know what happens really, unless whatever they report on, or it could be completely confidential. So that would be boring. That's the downside. But here, courts have repeatedly enforced arbitration clauses with similar broad language. So they're citing Fink v. Gallenbach. For example, the Supreme Court of Connecticut held that an arbitration clause mandating that, quote, any disputes arising under the employment agreement between the parties shall be submitted to the American Arbitration Association was, quote, all-embracing, all-encompassing, and broad. So this is one broad sentence, but Supreme Court of Connecticut says it's all you need. Indeed, the arbitration agreement in Fink was found to be broad and unrestricted, such that it encompasses tort claims as well as statutory claims. And then they cite this other case here, quoting, the inclusion of such broad language, such as any claim or controversy arising out of or relating to this agreement, quote, generally includes all claims, including tort claims. The broad arbitration clause in the parties' agreements similarly encompasses plaintiffs' contract claims, counts 1 and 2, statutory claims, counts 3 and 4, and tort claims, counts 5 to 9. Further, under Connecticut law, like federal law, arbitration must be compelled unless it may be said within positive assurance that the arbitration clause is not susceptible of an interpretation that covers the asserted dispute. Doubt should be resolved in favor of coverage. It cannot be said with such positive assurance that the arbitration clause cannot be construed to encompass the asserted claims in this case. Far from it. Indeed, by challenging the enforceability of the agreement, plaintiff has initiated a dispute on the construction, interpretation, application, performance, or breach of the agreement, which renders the entire dispute a proper issue for arbitration. Because again, she's saying the whole thing is an issue. The whole thing should be void. Well, you're not taking aim at that arbitration clause and saying there's something wrong with the arbitration clause, which means you need to take your grievance to arbitration. There is no congressional intent to render any claims asserted in the complaint non-arbitrable. While the FAA requires courts to strictly enforce arbitration agreements, that mandate may be overridden by contrary congressional intent. Actually, we have a long footnote. So before we get into this third argument, plaintiff must be compelled to arbitrate her claims. This is a whole argument in this footnote. Holy moly. It's like half the page. Plaintiff must be compelled to arbitrate her claims asserted against WWE because, like defendant, WWE is a party to the agreement, and all reasons asserted here in support of defendant's motion to compel arbitration applies equally to the WWE. In the event any such dispute cannot be resolved informally, all parties hereto agree that the sole and exclusive legal method to resolve any and all disputes and/or controversies is to commence binding arbitration under the Federal Arbitration Act pursuant to the procedures of the American Arbitration Association. And although Laurinaitis is not a signatory on the agreement, plaintiff should also be compelled to arbitrate her claims against him. Connecticut state courts have looked to federal law to determine the circumstances under which non-signatories may be bound to arbitration agreements. Interesting. The Second Circuit has recognized that signatories to an arbitration agreement can be compelled to arbitrate their claims with a non-signatory, where a careful review of the relationship among the parties, the contracts they signed, and the issues that had arisen among them discloses that the issues the non-signatory is seeking to resolve in arbitration are intertwined with the agreement that the estopped party has signed. Interesting. Oh, that's like a new realm for me. Cool. I'm gonna go and like Google this stuff, and the next time we get an update here, I'm gonna be like, I read up on this thing. Internal quotation marks, modifications omitted. By signing the agreement, plaintiff agreed to release all claims against Laurinaitis in his personal capacity and official capacity. Plaintiff's allegations and claims against Laurinaitis, this name is butchering me, are closely intertwined with her allegations and claims against defendant and WWE, and plaintiff must be compelled to arbitrate her claims against Laurinaitis. So, this is actually, even without getting into this non-signatory party argument, this is actually a pretty punchy footnote, right? You have all this focus on, oh, you have all these claims against me. You're trying to say this confidentiality agreement is just void as a whole because you're also saying I did criminal things to you. It's a civil action, but inherently you're asking for civil litigation against it, but you're still saying sexual harassment, trafficking. Besides the trafficking charge, is WWE responsible for the allegation that she got defecated on? Right? So some of the things that someone may lean and say, if that's true, it's not enforceable, this confidentiality agreement, so we're going to let this action move forward in court. Well, what about WWE as a party? So if a judge were for some reason to say, all right, we think that this confidentiality agreement is void between some parties, in part, but not in whole. And we don't think it's void between the WWE and Janel Grant. Well, there's another reason we have to go to arbitration. You can't really move forward with the court side until arbitration's done. It needs to be stayed until that's completed. And then a determination can be made. Does this need to move forward? And then I can still file a motion to dismiss with the court if arbitration is not enough and we don't end the action there. So this is actually a really, really punchy thing to put in a footnote here. Because all this focus was pretty much like void against me because of my actions. But there's another party here. And then, oh yeah, so this paragraph here. Let me check in on you guys over here. So Raymond Jackso says, so are they saying her accepting cars and cash means she can't claim she was forced to sign the agreement? Well, the cash from the NDA. And then Tracker, you've already answered, says, well, they're saying by not saying anything for X amount of time. And in Connecticut, they have that case law that says 2 months is enough time. And she didn't say anything until January of 2024. So almost just shy of 2 years, but well over 1 year, well over 2 months. That time passed and she didn't say, "Hey, I have a problem. I want to annul this. I was under duress when I signed this. I need to get out of this." She didn't do that. So, like Tracker says here, they're saying that by not saying anything for X amount of time and receiving the payments constitutes acceptance of the contract. There is a gray area here, though, unless I'm missing it. Sometimes, stream brain, while I'm reading it, I miss certain details, but did I read over anything that addressed the first $500,000 payment that was supposed to be paid in February of 2023? We had a vague assertion that she had already breached the confidentiality agreement. But we didn't really see... I didn't see citations for it yet. And it's just a filing, so I'm not saying that there isn't a citation. I'm just saying everything else so far, there's been citations, there's been quotes, and we don't really have something tangible to explain why in February 1st, 2023, if that installment wasn't paid, because maybe it was, maybe I'm interpreting this wrong, but if it wasn't paid, we don't really have a specific reason why, or a specific date from the defendant here, Vince McMahon, WWE, whoever, that this installment was not paid because a breach of the contract had already occurred before that installment date. We don't have the specifics on that, unless I missed it while reading, because sometimes stream brain. But let's get back to argument 3. You read that she breached and that they didn't make the first $500,000 payments in 2023. Thank you. Right, but it was really vague, right? It was just, she breached it. We didn't have like a footnote or a citation. So, the third argument, there is no congressional intent to render any claims asserted in the complaint non-arbitrable. I hate that word. There's a lot of words in here I don't like. While the FAA requires courts to strictly enforce arbitration agreements, that mandate may be overridden by contrary congressional intent. So we have American Express here, another big company. Such an intent may be deduced from the state's text or legislative history, or from an inherent conflict between arbitration and the state's underlying purposes. Here, plaintiff asserts 2 sets of claims, based on federal statutes, and neither implicates a congressional intent that plaintiff's claims are non-arbitrable. First, in count 1, plaintiff seeks to void the agreement based on the Speak Out Act, which renders pre-dispute non-disclosure clauses or non-disparagement clauses unenforceable in disputes involving sexual assault and sexual harassment claims. According to plaintiff, because the non-disclosure clause and non-disparagement clause in the agreement are, quote, the core terms of the agreement and are allegedly invalidated by the Speak Out Act, the agreement itself is judicially unenforceable. The Speak Out Act does not prohibit the arbitration of any claims asserted in this case. Based on the text of the statute, Congress intended to limit the application of the Speak Out Act to only non-disclosure clauses and non-disparagement clauses in pre-dispute arguments. Quote, no non-disclosure clause or non-disparagement clause agreed to before the dispute arises shall be judicially enforceable. Nothing in the text of the statute, the legislative history, or the underlying purpose of the act suggests a congressional intent to also render a related arbitration clause unenforceable. The Speak Out Act is thus not a reason to find that plaintiff's claims should not be compelled to arbitration. Now we have a long footnote. I think it'll be interesting because, I have like a top level understanding of the Speak Out Act, but what do we have contrary to it? So contrary to plaintiff's assertion that the non-disclosure and non-disparagement clauses are core terms of the agreement, such that the invalidity of which would render the entire agreement meaningless, the agreement contains other material provisions, such as the release of provisions and the payment provision. Indeed, the complaint itself admits as much by alleging that McMahon has breached a core term. Oh, that's a mess up. So now they're trying to argue the core terms. What was the language? Dang, they're using their own verbiage against them. Wow. Because she must have said, and I can go back and look at the initial complaint, because only some of this is in quotes here. But according to plaintiff, and they've said it twice, because the non-disclosure clause and non-disparagement clause, So these two things are, quote, the core terms. So did they say that in the complaint? These two things are the core terms. So now they're arguing down here. Oh, that's hilarious. That's lawyer versus lawyer right there. That's why every word counts in a filing, guys. So they argue, on one hand, that these two things are the core terms. So since those are invalid, everything's invalid. But in their own words, in that same complaint, they also say McMahon has breached a core term of the NDA, the payment. He paid $1 million, but failed to make any further payments. In any event, the agreement contains a severability clause, which states that if, quote, any provision of this agreement is held to be void or unenforceable by any arbitration panel or court reviewing an arbitration decision, the remaining provisions shall nevertheless be binding. So, assuming arguendo that the non-disclosure and non-disparagement clauses are unenforceable under the Speak Out Act. So, this is the hypothetical, for the sake of argument. Arguendo. Which they're not. This is hypothetical, but this is not it in the real world. The remaining provisions in the agreement are nonetheless severable and enforceable. And then they're citing it's a prenup case. The prenuptial agreement contained a severability clause that expressly contemplated that, if one or more of its terms were found to be invalid, the rest of the agreement would survive. Plaintiff may attempt to argue in opposition that the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, the EFAA, which was enacted on March 3, 2022, and renders unenforceable a pre-dispute arbitration agreement with respect to sexual assault or harassment disputes, constitutes contrary... Does this footnote go to another page? Okay, so we're extending this footnote to another page. So we're talking about EFAA, constitutes contrary congressional intent. However, the EFAA isn't inapplicable to this action because the EFAA does not apply retroactively. And there's case law for that. The EFAA applies to claims that accrued on or after March 3rd, 2022, the date of its enactment. It does not apply retroactively. It's the full quote. And the agreement is not a pre-dispute arbitration agreement because it was entered into on January 28th, 2022, after the alleged misconduct by defendant, which forms the basis of plaintiff's claims. I want to see the counter argument to this, but they're going to do oral arguments instead of making a filing for it. Or they're requesting to make oral arguments. But I want to see. And I don't want to order transcripts or something like this, but I want to know the response. The use of dispute in this context clearly refers to discriminatory conduct under the complaint, requiring the arbitration agreement to be entered into prior to the dispute, the discriminatory conduct. So this, yeah, I know. I wanted to crop oral arguments as part of the thumbnail for this, but I was like, let me not, because I hadn't read this yet, and I didn't know if it was going to be like very victim blamey type. I didn't want to make a joke of something that could actually be kind of like harsh to read. But this motion is really focused on, I'm on page 26, but I guess I should have known when I saw this that it would be very focused on legal arguments. There's so many. So let's go back to page 26. That was a long footnote, guys. It was if you combine these two footnotes and spaced it, it would be more than one page. So we read this footnote. This footnote was attached where? So much footnote going on. 9. Okay, this footnote attached somewhere up here. Where was footnote 9? Okay, we're here then. Second, we need an index for the footnotes of this. Second, counts 3 and 4 of the complaint assert claims based on the Trafficking Victims Protection Act, which similarly imposes no prohibition on arbitration. The TVPA and its legislative history are silent on the issue of arbitration, and no inherent conflict exists between arbitration and the TVPA's underlying purpose, which is to combat severe forms of worker exploitation that do not amount to actual involuntary servitude. And then, let's see. Indeed, courts around the country have repeatedly compelled arbitration of TVPA claims. So, there's precedent. Hey, in this case, they went to arbitration. Well, that's one case. So, it's at least one example. Are we gonna get more? Yeah, so we got two. So we got two examples there. They gave us two. So accordingly, there is no contrary congressional intent to render any of plaintiff's claims non-arbitrable. This court should stay the action pending arbitration. So, by the way, this should go to arbitration. And you need to stay this action here. They shouldn't be proceeding at the same time. Courts have the inherent power to grant a discretionary stay of proceedings pending arbitration. In determining whether such a stay is justified, a court must consider 1, whether there are common issues between the arbitration and the litigation. 2, and it's the exact same thing, right? This whole thing that we're litigating, because Janel Grant says we want to litigate this entire agreement. We're saying this whole agreement is void. It's unenforceable, right? The whole thing. But then the arbitration, there's a clause in there that says anything in this thing, this whole thing, the whole scope of this should be arbitrated, right? So whether there are common issues between the arbitration and the litigation, it's the exact commonality. It's the exact overlap. And 2, whether those issues are likely to be resolved in arbitration. 3, whether the failure to grant a stay will prejudice the defendant. And 4, whether the stay will prejudice the defendant. So this will probably be a big part. I don't want to say the word core, a core part. But this will probably be a big part of if they do oral arguments in front of the judge. Well, no, this will prejudice my client, Your Honor. Bunch of cases here, and in addition, the court must consider factors such as the desirability of avoiding piecemeal litigation and the degree to which the cases necessitate duplication of discovery or issue resolution. To this end, a discretionary stay is particularly appropriate where there is significant factual overlap between the remaining claims and the arbitrated claims. And they're quoting here that it is well settled that claims are appropriately stayed when they involve common issues of fact and law with those subject to arbitration, or when the arbitration is likely to dispose of issues common to claims against both arbitrating and non-arbitrating defendants. In such cases, a stay is warranted in part because the prior litigation or arbitration is likely to have preclusive effect over some or all of the claims not subject to arbitration. Right? So if we argue like one of your claims in arbitration, it's all going to be related, right? Because if you're arguing one instance of sexual harassment or trafficking, right? Those things are, trafficking is kind of like a pattern or a sustained act, an ongoing thing. It involves multiple physical actions. So if you're going to argue like part of that, you can't separate it. Because all claims alleged in the complaint fall within the scope of the arbitration clause, the court should stay the action under Section 3 of the Federal Arbitration Act. And then they cite this case, Katz v. Selko, saying holding that a stay of proceedings is necessary after all claims have been referred to arbitration and a stay is requested. Even if a court were to find that not all claims are arbitrable, and it should not, a stay pending the resolution of the arbitration is nevertheless justified. It is appropriate as an exercise of the district court's inherent powers to grant a stay, quote, where the pending proceeding is an arbitration in which issues involved in the case may be determined. So, for the foregoing reasons, defendant respectfully requests that the court grant his motion and compel arbitration of all claims asserted in the complaint and stay the litigation pending arbitration. So all of his attorneys signed this. And this was yesterday, right? This went over yesterday. And at the beginning of the stream, we looked over this 1.5 page sort of response. And they're just like, can you please strike this? This preliminary statement is a platform to launch vicious falsehoods attacking Janel's moral character in a transparent attempt to harass and intimidate her into submission. Now, I want to be clear. When I read this, I thought we were going to get a bunch of mudslinging. But really what we got is we lived in the same building. We did whatever from 2019 to 2022. You claimed I pooped on you. And you went back downstairs to your fiance without incident. Nobody noticed. It wasn't. That was what we got as far as what this could really apply to. So when I read this, and I saw 26, 27, 28 pages, I thought there would be mudslinging. Personally, after reading it, I thought we just got a lot of case law about arbitration being the correct route. At least, if not in whole, at least the correct route, so that the rest, anything else, any other proceeding, must be stayed for the duration of the arbitration proceeding. So this is a very interesting response. And that's the problem. So that guy McFly, do you think it struck a nerve? Do you think it struck a nerve that his response pointed out and made it public knowledge? How much was that mentioned in the complaint? The duration of the relationship with Goncalves. I'm going to revisit that. But I'm thinking something struck a nerve. And it was the mention of her being in a relationship for the whole duration of it. Because there wasn't much else in there besides, mentioning there was an agreement for $3 million previously. And if I pooped on you, why didn't anybody notice? Why didn't your fiance notice I pooped on you if you went right downstairs back to him? Those are like the main things. You were engaged. You signed an agreement already for money. And if you had gotten pooped on, you went right downstairs in the same building, right back down to where you were living. And you didn't want me to move out of the building when we signed this agreement. You wanted to make it a term that I wouldn't move out of that building. Why would that be? Why would you want me to stay living in the building? If I'm trying to have you sign a mutual agreement and a confidentiality agreement for us to part ways and go our separate ways from each other. Why would you want to tell me not to move out of the building, that you'd come upstairs and I'd poop on you and you'd go back downstairs to your fiance? Right? This is how, okay, so Barbara, I'm sorry, everything I know about Vince McMahon tells me he's probably guilty of everything she says and more. And that's really where I didn't care about the initial filing. I heard, all right, yeah, the instinct maths, right? The gut instinct maths. I don't know about the reality math, but I can see it. I can see it. But I just don't know. So I've listened to it being read by others. So that's why I'm thinking I may have tuned out if they were reading parts where she voluntarily detailed, her background information. Like, this is I lived here, this is the address, and I was with my fiance or whatever. But I do remember her talking about the parents and caring for the parents. So was there a part in her initial complaint where she details, I'd have to go back to my fiance and I'd be traumatized? Like, if that was in there, I don't remember it being like this visual of you guys are in the same building rendezvousing. And it certainly wasn't mentioned in her thing that she didn't want him to move out of the building. So, and I want to say hey to Blue Queen TV and hey to Jameer. And then did I miss anyone further up too? I think we've got everybody. But I just think that that's very interesting. I don't think that stuff in here was vicious. vicious falsehoods. It was, you texted me, you didn't want me to move out. It doesn't really matter that we did all of this and you never said anything. And this could all be on the lawyer, right? This type of response could have nothing to do with Janelle's own words, or she might not even know the statement was written this way. But sometimes when lawyers lawyer this way, it's like that the filing you're referring to was a bunch of case law. It was like 3 pages of indices of case law and footnotes that went on for more than 1 page about case law. And yeah, that's there's too much. So I don't know. And I think it's interesting that, you don't want to go the arbitration route. You want to go the public route. And maybe we'll see a counter argument. Maybe she'll agree to it now at this point. But you can get a financial outcome from an arbitration or going all the way through court. But if you're hoping for a settlement without having to arbitrate, you file things with the court and ignore the arbitration clause. Because the shock value of you putting out statement January, filing in January, could motivate a settlement to keep things out of court. I don't know. So I'm definitely interested in the response from Janel Grant's side, especially on the argument of arbitration. Because again, that will tell us we want this to go something that's more accessible versus, are they going to argue that, oh, never mind, only parts of the non-confidentiality, non-disparagement clause. It's not just those 2 core parts, or it's only those 2 core parts that we want to go after. We're not saying the whole thing anymore. But Barbara's saying she also kept her mouth shut because she probably wanted to get another job somewhere and then realized no one would hire her because she had the stink. Stop! That took a turn at the end. Stop. I'm reading it all intently and seriously. Like, yeah, no one would hire her because, word in the industry. Or whatever. Or he would put in a bad word. He's a powerful person. And you just go, because the stank of McMahon. The odor of mendacity. That's crazy. And on the 8th anniversary, you guys, and let me pull it. It was TMZ that said it, right? Who else would say it? Yeah, I'm not making it up. 8-year anniversary. Dang, how time flies. So, 30th birthday, 8-year anniversary. And they zoom in on it and give her a nice little party hat. You guys. You guys. Well. Oh my god. No, exactly. It laid out perfect. It's probably so your humor is very like instinctual, so I can picture you writing it and sending it exactly like that. Oh, yeah. Definitely. I wrote 2023 the other day and we're in April already. And then that guy McFly says, she said she couldn't pretend to be busy at the office. She was known as a literal cum rag. That part I remember. Okay, so I think I watched it in parts because where I was first streaming this, they went off on such a tangent about slang that had nothing to do with with Janel Grant's motion, right? But when they read that, they had burst out and they went into Netherland, just going into the mudslinging that goes on in legal filings and cases, and they were talking about other cases that I wasn't really familiar with, where dirty laundry was just getting aired out, like celebrity divorces and stuff like that. I don't think it was a harassment cases they were talking about. Maybe it was a lot of Tasha K stuff came up too. And then, yeah. So that a big part of like, it was like a 3-hour stream I was watching and they didn't get through the whole filing because they read that and just woof. The official title is Come Dumpster 2. And then they talk about the Dumpster Bros case, guys. The Take Your Swang. But with that, on a very interesting note, and on a note that didn't kill my appetite, thankfully, because I'm hungry and I should eat something, I'm going to jump off of here. And while I don't plan to, I didn't care about this case because you hear enough about it when there's like a buzzword, right? It's like the world hears the word poop and everyone talks about it, right? You can't not talk about it. And it happened to be in a very awful context in the case of in this filing. But I don't know. I wasn't really interested in covering it. That's why I didn't do a stream on it initially. If there's written arguments, if we get motions, if we get to see some of these arguments on arbitration and possible estoppel because a payment was made and then this was a breach of contract, that stuff's a bit more interesting to me. But as far as the salaciousness, I think we started at the top with this one. And the rebuttal to that is only, well, if that were true, then why blank? Or that's not true because blank, right? It's pruning down. I don't think we'll escalate any higher on the salaciousness with this one. So maybe it will. And I just want them to sign a trial date in the damn Clenny case. They won't. I mean, they had the attorneys on the... they had one of the attorneys getting on the stand at the exact hearing they were supposed to set a trial date for. It was a status hearing, right? We could have. It wasn't necessarily supposed to 100% have been scheduled. But then the attorney's on the stand as a witness, so giving testimony. Fun stuff. And sorry that was messed up yesterday with the feed. I still haven't found any feed to replay from the beginning of that hearing. I started in the middle of it. So you've got a stream from yesterday with a terrible bitrate if you want to see the second half of Courtney Clenny's motion hearing. With that, I'm going to jump out of here. Thanks so much for joining, and that was a really good laugh. I don't even know where it was. I just see you saying, I know you're going to laugh when I read it. So thanks so much, you guys. If you think anything further with this is interesting, we can do a live chat about it anytime. You guys all have a good night. Bye.